So Tom, as I was reading the Bible today and we were discussing the punishment of disobedience, which might have some linkage to divorce law, because I think you once said that there are two things that the law really does well in divorces. That would be?
One would be give money away, and it's even broader than divorces. It's just the court system in general. We do two things well, is we punish well, and we give money away well. So if you have an injury, we're really good at figuring out how much you should be compensated. If you commit a crime, we're very good at punishing you, sanctioning you. Beyond that, we don't do much very well, in my humble opinion.
And that would include divorces or dissolution of marriage, as it's commonly called.
It's now dissolution. You get your marriage dissolved. Back, Richard, when you and I got out of law school in the last millennium, 1972, Missouri was a full divorce state in that you had approved grounds to get divorced.
Can I stop you right there, Tom?
Yeah.
I forgot to introduce you, but even though...
Well, this isn't my first foray for these good folk.
This is not your first
and
rodeo.
And I hope
here.
I have a different shirt on for you folks than I had the last time. It was a big dilemma this morning between myself and my wife.
So this is Judge Tom Frawley, who's retired now but still active with respect to various assignments that he does with the law. One of the interesting things is this is Tom's fourth appearance, and he's also going to do a fifth one because the topic we're going to be talking about this morning, divorce or dissolution of marriage, is so broad. So he holds the record, I think, for the coveted position of the most times participating in our Parkway Speaker Series. Sort of reminds me of Saturday Night Live when the guest host always had a number of times, and there was the coveted 5 appearance award that included Steve Martin. And Tom would do a great job, incidentally, at Saturday Night Live. But be that as it may, some would say, my wife would say, how many times do we have to take advantage of Tom's good nature? And the answer is, he loves it because he has a great passion for the law. He's still contributing after many years in the private practice and then on the bench. So Tom, thank you for being with us. We look forward to your presentation. We're going to be talking about divorce law in Missouri and a whole lot of interesting stories potentially too.
Well, I'm happy to do it, Richard, and with my inability to stay on topic or stay focused, there will likely be a chapter 6 or 7. And as my wife said every morning, I don't care where you go, you just can't stay here.
What a wonderful thought. So before I made my introduction, you were talking about how the law changed early on in our legal careers with respect to divorce.
When you and I got out of law school in 1972, Missouri was a fault divorce case, which means you had to prove grounds to get divorced, and there were also defenses. One of the grounds, as an example, one of the grounds was that a spouse was having an affair. And one of the defenses, what was called condemnation, meaning, well, you condoned by your behavior the fact that I was having an affair, meaning you knew I was having an affair with this other woman, we continued to have sexual relations, and therefore you condoned you condoned my behavior. Secondly, and remember, the judicial system was created back in the 1700s when all the other branches of government were created, at which time women couldn't own property. So you've got a system that was created that was completely foreign to the world we live in today. And so back in the 70s, all you could do was get divorced. You could not yet have a separate action to divide property. And to get what was then called alimony is now called maintenance. And if you settled your divorce and you came into court, you had to have 2 witnesses with you who could vouch to your credibility and you're respected in the community. Well, notwithstanding those of us that were able to settle divorces, telling our clients, make sure you bring 2 people with you. They seldom did. So therefore, you had to find 2 people who could vouch for their credibility and their quality as a person, in the courthouse, which generally was the people who did the divorce right before yours, who knew you for maybe 10, 15 minutes while you sat in the courtroom waiting for your case to be called. So it sort of had its own idiocy to it in the way we handled it. But your client's there and they want to get divorced, and somebody's got to vouch for their credibility, and so we just traded off, which is the way we kind of do the marriages too. When we do the marriages in the courthouse, you're supposed to have a witness, and usually it's the people getting married right after you. And so therefore, the last couple, best to have somebody with them, because everybody else is gone. So
Wow.
in 1975, the Dissolution Marriage Act was enacted by the legislature, and it's evolved, if you will, during, what is that, roughly almost 50 years now. It's no fault, it's modified no fault, meaning you have to allege and prove the marriage is irretrievably broken and cannot be preserved. And that's all you have to allege. It can be denied, and somebody could say, well, I think a marriage can be saved. And that would be an issue to be heard by the judge. If the judge said, yeah, it can be saved, the judge can deny the dissolution and grant a legal separation, or it can just deny the dissolution and send the people on their way if they don't want a legal separation. So
and
seldom happens, Richard, seldom happens.
And those are the magical words, irretrievably broken and cannot be preserved.
Those are the magical words.
And you say that under oath, and that's good enough to get a divorce.
That's what you allege in your pleading, and then you're asked that question by the lawyers. Now, the problem, of course, is that we lawyers are terrible at framing questions in a settled case. And so what we do is we read from our petition. And of course, as a result, your question has got a double negative. And therefore, the answer should be yes. But of course, when you say, and your marriage cannot be preserved, most people say no, because they mean the marriage can't be preserved. The best one is with respect to what we used to call alimony, now call maintenance. They say, you're not asking for maintenance. The answer to that should be yes. But meaning the person sitting there is nervous. They know they're not asking for it, so they answer no. So one of the duties I guess I have is to sit there and listen and make sure that either A, the question isn't a double negative, and if it is a double negative, that the answer is correct. Otherwise, down the road, who knows if somebody came back and challenged it. So yeah, those are the magical words. Cannot be preserved, irretrievably broken.
Judge Frawley, would you say that you've had a lot of experience with divorce cases over the years?
I would say I have. I did.
In what two capacities, correct?
I was in private practice. These people probably already know this. They probably know it better than me. I went in private practice in '72. I was there till September '91. Went on the bench September '91. Retired February 17 when I turned 70. Started with a small firm in '72 with taking, as you do with a young lawyer, you get what everybody else doesn't want to do, which was divorce work. So I developed a little bit of a expertise, a little bit of a passion. So when I left that firm in the 80s, I was doing nothing but domestic, nothing but divorces. Even though they're now called dissolutions, we still call them divorces. And so I did probably nothing but divorce from roughly 1980 till 1991. And on the bench, I did nothing but divorces out of my 26 years, or 20 of them. So yeah, I've done a fair number.
And you obviously were sitting as a judge in the circuit court of the city of St. Louis.
That was my primary assignment.
But you sometimes helped out in St. Louis County?
Did some in St. Louis County, did some divorces in Lincoln County, did some divorces in Warren County, and I've done divorces because of the quote expertise I'm perceived to have. I've done them in every county from St. Louis to Columbia, except along Highway 70, except Callaway, and every county between St. Louis City and New Madrid, down 55, except Bollinger and St. Genevieve. So I've seen it a lot of places. And there's been other places in between, including Wright County, which is off of Highway 44, and the post office and the courthouse are in the same building, which is about 1 story high.
Are there some differences in culture and in the way that divorces are conducted in the rural counties versus the urban counties that you've observed?
Yeah, I mean, there's the culture. It's different more in the context of outstate people are more cash poor, meaning they have a lot of land, more than 401ks and retirement plans, and they're more blue collar folk in terms of hardworking and have bosses rather than being bosses. So you've got to deal with people who have less control over their day as it relates to division of the children in terms of custody, and may have to travel a distance. So you have that kind of issue that you may not have in the city or in the county. But basically, the issues are the same.
As I recollect, when I was handling a few divorces, and I was never good at it, we'd have what were called non-cons or non-contested hearings, and then there could be contested.
Correct.
What are the differences?
Well, non-contested is exactly that. People work out their differences with respect to getting divorced, division of property, whatever kind of child support or maintenance there might be, and also custody of their children, if they have any. And that was a situation where before 1975, you needed to have 2 witnesses to come in and verify how credible you were and that your reputation in the community for honesty was good. Contested divorce means that either A, all of the issues are unresolved, or B, some are resolved and some are not, meaning you might have resolved custody, but you can't resolve the division of property. And so you put on the settled part, the custody part, and then they put on their evidence and I decide who gets what property.
So the judge in a bench trial, in a contested matter, makes decisions.
Right, there's no jury. Texas used to, maybe they still do, used to have a jury trial. Divorces were in a jury trial, which has got to be just a complete circus. But Missouri, as long as we've been practicing law, it was always bench trials only.
As a practitioner, as an advocate representing a husband or a wife, is the appearance and personality of your client important to the judge?
I think it is. And one of the vital pieces, I think, in private practice is knowing your judge, which is why trying a case as a St. County lawyer going out to Warren County or Lincoln County or further than that is a little difficult because you don't know the judge at the level you do when you're quote home circuit, and so knowing the judge's inclinations is important. There was a judge in one of the counties neighboring St. Louis who this is in the mid-'80s, completely intolerant of a spouse having an affair. And I represented the wife, and I knew that of the judge. And although my client wife was not the most likable person in the world, knowing that the fact that the husband was having an affair, I just needed to get her on the stand and off in as short a time as possible. And then as soon as the husband got on and asking him about the affair, and we had evidence to prove it, so we didn't even want to lie about it. So knowing your judge is important. I had a custody case back in the late 70s with the way the hair was in women back in the 70s was out to here. Wonderfully nice lady. She unfortunately was having an affair with her boss, and they had 3 kids. I didn't know much about the husband, but I knew I needed to figure out how to make her come across as a good mom, which she was. And knowing the judge that I was in front of did not think kindly of women having affairs. So I told her, said, you need to look like Beaver's mom. okay, and you need to come in a nice high collar dress with white pearls, don't have to be real pearls, but a white necklace. You need to get your hair under control, and you need to come in wearing Mary Jane shoes. And yes, I do know what Mary Jane shoes are.
What are they? Because
They're,
I didn't.
they have a strap across your ankle, and they're low heeled, and usually they're black. And so she came and she looked.
Like
I
June
put her next to
Billingsley.
Beaver's mom. It was like June Cleaver, and because she was a wonderfully nice lady and a wonderfully nice. I knew she'd be a good witness. I just needed to make it clear that that her appearance didn't scare the judge off, if you will, on the nature of what a good mom she was. And we put on the case. She did really well. What helped also was her husband was a complete jerk, and he came across as a complete jerk. But yeah, so how you dress your client's important, and the other part is you got to make sure you don't try and make them into something they're not. I mean, if your client is a guy or a gal who's working really hard, and maybe it's a guy who's works in a garage and he's covered with grease day in and day out, putting him in a coat and tie makes him uncomfortable. And don't put him in a coat and tie. So you got to be conscious of keeping your client comfortable, but yet making it clear that the judge knows that this is an important day for your client, and that your client respects the system and respects the judge and doesn't come in looking like he's disrespectful. So that, just like anytime when you meet someone for the first time, you draw an opinion. Sometimes it's inaccurate, but this is their meeting, the judge meeting them for the first time, and you want to make sure that they make a good first impression.
I remember a story that we were discussing before we went on.
While you were reading the Bible?
While I was reading the Bible to you, which was a joke, folks. In any event, I think you were telling me how there was a 6-year-old boy who testified in a case which was very unusual. What happened there?
This was a case in the mid-'80s, and I was representing a guy, a dad, good. Of course, I'm not going to tell you all my clients were good people. I represented people I didn't like, but these are representation. I did the best I could with. So if it makes it sound like every client I represented I really liked, I didn't. I was telling Richard before we got on about a client I hated him. By the time he was testifying, even I wouldn't have given him his kids. But this is a case where my client had gotten divorced. Might have been a paternity case back then. But anyway, they already had an order. They had gotten an order for a custody order, and my client was telling me that his 6-year-old boy, his 6-year-old son, was telling him that mom was sleeping when the child was there with her boyfriend. And I said to him, "What evidence do you have?" And he said, "What evidence I have is my son. That's only 6 years old, and it's going to be tough to have him testify." So we put on the evidence, and mother denies categorically that she's sleeping with her boyfriend. So I went to the judge and I said, "I want to put the 6-year-old on." And the judge said, "Well, I'm going to let you put the 6-year-old on." So the judge, he's 6-year-old. I'm going to ask him like 5 questions. I'm not going to ask him who he wants to live with. I'm not going to ask him if he likes his mom, if he likes his dad. I'm just going to ask him 5 questions or 6 questions. So after much back and forth, and of course mom's lawyer was jumping up and down and yelling and screaming, the judge finally said, "Fine, but you can only ask him 5 or 6 questions, and it can't be a bunch for opinions." So I brought him in and I asked him his name, and I said, "You spend weekends with your mommy and with your daddy?" "Yes, I do." "When you're at your mommy's, when you get up in the morning on a Saturday, what do you do?" He said, "Well, I watch cartoons." "Where do you watch cartoons?" "I watch them in mommy's room, and you sit on the floor or somewhere else. I get in bed and with mommy and also with Joey." And so the end product was my client got the child because, not necessarily in part because mom was sleeping with her boyfriend, but she lied about it. And that was always something that I told my clients, don't lie about it. Just hit it head on. And Richard, you tried enough cases too, that it was always you always tried to make sure if you had something bad, you asked your client that. Whatever was bad, you didn't leave to the other side to bring out. If your client was sleeping with somebody, you asked them so that you could control how it was presented and maybe to control the damage rather than leave it alone and make it sound like you were trying to hide it. But there was also the risk that the other side didn't know about it. And I had one of those where we went all the way through the trial and nobody asked my guy whether he was sleeping with anybody. But I didn't ask her either because I didn't know and I didn't want to open that door. And when it was all said and done, I think they both were each of them was having an affair. And it was, the memorable part about the case was that mom had not forged the children's birth certificates, but had misrepresented their birth dates. Their birth dates were 1 year old. They were 1 year younger than the birth year on their birth certificates.
Why did she do that?
The best I could tell was it got them in kindergarten earlier and therefore moved them through the schools because they were, in her perception, and I think correctly, very bright. But it was.
But that was a lie.
It was a lie. It was a lie, but this was in the 70s, and judges were reluctant at that time to give children to younger children. They were young. They were probably 6 and 7 to dads. It was back in the day what was called the tender years presumption, and that was the children of tender years should be with their moms. And so, notwithstanding all of that, we didn't prevail.
Legally, what does the law in Missouri say about the conduct or bad conduct of a husband or wife? How is it relevant in deciding issues?
It's relevant to the issue of primarily property division, and can be with respect to maintenance, or what used to be called alimony. Conduct, it has to have an impact on the marriage, though. In other words, one of the judges I tried a bunch of cases in front of when I was in talking to him, and was in private practice about a fair in a case, he said, Frawley, let me ask you, is the fair the product of the problem at home or the cause of the problem at home? Well, Judge, I don't know. And largely that, I've kept that as I've gone through when I went on the bench, that I don't know that we always can tell if someone's having an affair, whether that's what caused the marriage to break up or whether the marriage was already kind of in the dumper and this was just what they were doing.
If it's the latter, then that's liable to not have as much impact on dividing the property.
With me, it had, I seldom, it had much less impact if you couldn't, you couldn't discriminate whether it was the cause or the product, or B, it was clearly the product. The kind of conduct that really, what I gave way to was financial misconduct with respect to your girlfriend or your boyfriend.
What does that mean?
You're taking trips with your girlfriend, going down to the Bahamas, you're going over to Mexico, you're going to New York City, are you going to expensive restaurants, are you renting motel rooms, so that you're spending money that the marriage could otherwise be using or saving on your girlfriend or your boyfriend. Or are you hiding money? Are you spending it? Are you gambling it away? Are you, excuse me, spending it on toys for yourself? So it was more the financial misconduct, and clients would always come in when I was in private practice and say, well, suppose I start putting money away. Can I hide it? I said, you can hide it, but I don't want to know about it. And if you hide it and they find it, you'll get none of it. If you hide it and they don't find out about it, you'll get all of it. If you don't hide it, then you'll get 50% of it. It's pretty much 50-50. It's your decision. Do what you want. I would then say, but if you're gonna do it, here's how to do it, in a way that you might be successful. One of the common phrases I used in private practice with clients, and I used on the bench all the times, pigs get fed and hogs get slaughtered. And so you want to put it away, you're being a pig, or you might be a hog. And if you keep it divisible, it'll be a pig, you'll get 50% of it. Now, it doesn't have to be 50%. Conduct can be a determinant of you getting more or less than 50%. But the real variable in division of property is value. If let's say you have a piece of real estate and wife values it at $100,000 and you value it at $80,000 and the judge gives her $50,000, from your perspective, she got more than 50% of the property. From her perspective, she only got 50%. If on the other hand, the judge values it your number of 80 and gives her 40, you view it as a 50-50 deal. She, on the other hand, views it like she got less than 50%. So valuation is a critical piece. Taxable asset. If you've got 100 grand in a 401k and 100 grand in a bank account, she gets the bank account and you get the 401k. It's not a 50-50 division because the 401k is tax laden. The bank account is not. So 50-50 is the theory, but there's variables, conduct, and whether something's tax laden or valuation.
Speaking of 401ks and pension plans, does that typically go to the party in the lawsuit whose 401k and pension plan it is, or can the law distribute the results of the 401k or the pension plan?
The law, you can do either. It doesn't have to be divided. It can be divided, it doesn't have to be. In other words, if you have 100 grand in the bank account and 100 grand in the 401k, you could say, well, after taking tax consequences, 401k be worth really 80. So I now I've got a real estate of $180,000. So mom will give you the bank account, but you got to pay him $5 grand to equalize the property. Or you can divide them 50-50. So 50 grand from the bank account goes to dad, and 1/2 of the 401k goes to mom. The way it's divided is what's called a qualified domestic relations order. I know the acronym pretty well. I'm not sure I got what each of the letters stands for. But what it is, it's an order that's sanctioned by federal law that is sent directly to the plan administrator that authorizes the plan administrator to create a separate account for the non-employee spouse where they transfer the property. So whatever it's worth on that day goes from employee, 1/2 of that, to the non-employee spouse. So that way everybody gets a true 50-50 division. You don't have to worry about taxes. And then it's taken out by the non-employee spouse who generally has a lower tax bracket. So they end up getting more of that 50% division because it comes out at less taxes. Same thing's true with a pension. If a pension's payable at 50, let's say 65, and the folks are 50, you do a qualified domestic relations order, which divides the pension. It's a little more complicated.
But the employer is going to be sending out 2 checks, one to the ex-wife and one to the husband.
But the pension, because if the employee is still working, some of the pension is going to be earned post-dissolution. So the order the order's a fraction of the amount. It's 50% times the amount the employee gets when he or she retires, times a fraction, the numerator of which is the number of years married while working, the denominator of which is total years working for that company. So although I never thought algebra would be important when I was in elementary school, apparently it has become such. But yeah, it's divisible. And the pension, from my perspective, was always an important thing for the non-employee spouse, especially if they had not been in the workforce, to make sure it's when they get to an older age, there's a protection, giving them all the cash. They may spend it on of necessity, and therefore they have no protection in the future, but it's divisible.
Here's a hypothetical. Suppose that during the marriage, one of the spouses, let's say the wife, inherits $500,000 at the death of her father. And then subsequently, the parties want a divorce. How does that $500,000 of inherited assets impact the division of property and any other financial issues in the marriage?
Kevin, how much time do we have?
So it's very
Okay.
important, I take it, and
No,
complex.
it has its own complexities to it. So there are two types of property: marital and non-marital. Non-marital is property that you inherit. Non-marital is property you received as a gift. As an example of a gift, the wife's engagement ring was a gift. It's non-marital property. Gift is exactly what it would sound like. So under the tax law, parents can give their kids a certain amount at the end of every year. If that's given to grandma and grandpa, give it to daughter, that's her gift. All right, now, the next complexity to it is when daughter gets the gift, and I know that I'll come to your exact hypothetical in a minute. If she puts it in an account in joint names, it now becomes marital property. And it's subject to division. It doesn't have to be divided equally because she contributed the whole amount. If she keeps it in an account in her own name, then it remains separate. But it has potentially a marital component. So to take your $500,000, as she inherited it was, did you say the wife? I think you did.
Yes.
The wife inherits it, she puts it in an account in joint names, it now becomes marital. So when they get divorced, assuming it's, let me change the facts a little bit. She gets $500,000 and she buries it in the backyard, okay? When they get divorced, it's remained separate because it's always been in one place and it didn't get any better, it didn't get any worse. It's all hers. She puts it in a bank account, and it earns interest, but she never contributes anything to it. The interest is marital. The $500,000 is hers. The interest is divisible.
Even if that bank account was just in her name.
Correct.
And she didn't mingle those
Correct.
assets with the marital assets.
Correct. If she commingled by contributing to the account, it becomes a tracing issue, and assuming she hasn't withdrawn any money, the tracing's easy. Started with $500,000, the interest that's earned, she's contributed, the $500,000 would be recognized as her contribution. If she kept it in her own name, it would go to her, and everything else would be divisible. If she's contributed to it, it's a circus.
Because
Okay. Well, Richard, let me ask you this. Let me give you a hypothetical. If you inherit $1 and you put it in an account in your name, and the next day you earn $1 and you put it in that same account, and the second day thereafter you withdraw $1, which dollar do you withdraw?
we don't know because it's been commingled.
Commingled. So it becomes a real circus. And it comes down to tracing, and it really comes down to what's it all worth today, what did they spend the money on, how much money came out, how much money went in, and there certainly has to be, from my perspective as a judge, a recognition that the account started with $500,000 of wife's money. Obviously, if the divorce is 20 years later, that $500,000 has less meaning than if the divorce is 2 years later. Let's suppose that she gets that $500,000, she opens an account with a brokerage firm and invests it in a whole bunch of stock. Account's still in her name. But then there's stock bought and sold, and the stock that's there at the commencement isn't there at the end. So you now have a question, if it's still in her name, how much of appreciation is the product of, or the stock, then your stock's the product of, or how much of the dividends that the stocks, the original stocks created, bought the new stock. The dividends are marital because they were earned during the marriage. Appreciation is not. So, example, you come into a marriage with a house, you keep it in your name, it was worth 120 when you got divorced, when you got married, it's now worth, and it had no debt on it, it's now worth 180, it's still separate. You kept in your own name alone, there was no money put into it to improve it, there was no debt on it, the value increases solely appreciation, it all accrues to the person who owned it. Unfortunately, life is not that simple. Usually you put money into it to put in a new bathroom, you probably paid down part of the mortgage, even though you kept it in your name, and so you've got to get the numbers and you've got to work it out and figure out how much value do you think, and there's a formula. I used to know the name of the case, but I can't come up with it right now, on how you do it. But you need to know what it was worth on the date of marriage, well, how much money went into the property to reduce the loan, how much money went into the property for improvements, and what it's worth today, and you do an algebraic calculation and you come out with a number.
Sounds like a divorce lawyer has to have some math experience and skills.
Yeah, you do.
And accounting.
You do. When we got out of law school, there was what was called the $500 divorce. And that was the bread and butter of those of us in small firms. Because it was basically, they paid you cash, and you didn't report it, but they gave you a retainer of $500, you got it done, it was pretty simple. But now even the simplest divorce is not the simplest divorce, because if they've got property, sometimes you got this marital separate issue, you got a valuation issue, and so yeah, you need to have some financial skills. One other piece to your hypothetical is the more of the cash of that $500,000 that goes to the wife, that impacts her need, if you will, for maintenance. Not the cash itself, but its income producing capacity. So in other words, if she's got $500,000, she can invest it, let's say, at 4%, so that would be, what's that? $20,000 a year that she would have to expend for herself.
And that would reduce if she was entitled to maintenance.
If she's entitled to it, it would reduce her need from husband because she's got 20 grand, arguably, of her own production to pay towards her expenses.
How about this as a maintenance question? Because I remember seeing it all the time. Let's say that the husband has been a stay-at-home mom, and the kids are now all grown up, educated, and out the door. And the husband wants the wife, who has a big-time job, to pay maintenance. But the argument would be, no, you should go out to work and earn your way yourself. The court should not grant maintenance. What's a typical resolution of that issue in your experience?
Richard, I hope if nothing else, these folks are coming away with the following, that your examples are very easily presented and seemingly very simple. Unfortunately, they're not.
Right. So,
to address your situation. So the first question is, what could husband make? And the first thing the lawyers do is they'll hire a vocational expert to determine what this gentleman could do. Well, does he have a college degree? Does he have a master's degree? Is he a high school diploma? What has he got? Folks, everybody can make $22,000 a year is what the evidence will be. Any vocational expert can, well, he can at least make 22 grand a year. Now, not 24 grand, not 18, not 1,500 a month or 2,000 a month, but $22,000. That's sort of the number. So the question is, am I going to impute income to husband of $22,000 or more? So that's the first question, is what is his earning ability? How old are the children? Does he need to be home? Can he earn more than the daycare cost for the children? If he can't, then it's sort of, does it make any sense for him to go into the workforce and pay daycare? And I'm going to answer that in a minute, because the answer is yes. So then the question is, what are his needs also? Is he going to stay in the marital home? Is he going to move out? What kind of needs does he have for himself? And also, what is wife's ability to pay? If she's making $400,000 or $500,000 a year, then obviously her ability to pay is a little greater than if she's making $80,000 a year. Also, what was the standard of living during the marriage? So, does he need to go out and get a job? The answer is yes, he really does. Absent the daycare issue, absent does the child have special needs, or any of the children have special needs, absent
A disability.
a disability that he can't work. So the question, as I said, then becomes, what is he capable of earning? And the lawyers will present evidence that he's got a college diploma or he's got a master's degree. Before they had kids, he was working in this field, and that he could earn 40 grand a year, 80 grand a year, whatever it is. And it's then up to me to determine whether I think he has that capacity. And it's got its own nuances, and I tried a case where wonderfully nice lady. It started in an insurance firm, and with a high school diploma, right when she got out of high school. 25 years later, she has got a fantastic job. She's earning a very nice income, and far in excess of what you would expect someone with a high school diploma in the world of today. She marries a fella, and his wife is deceased, and he has 2 or 3 or any number of kids who are young, and she helps raise them, and then they get divorced. Well, she's got a high school diploma. She's able to go back in the workforce, but she's not able to go back in the workforce and earn what she was earning because she's just got a high school diploma. And her skill set, in some respects, has been surpassed because the world's now more technological. And so the question becomes, is that her husband's lawyer wanted me to impute to her what she was earning when she, quote, retired to raise the family. And that wasn't available to her. So there's an issue there that has to be resolved and determined at what rate of pay are you going to impute this to this person who has not worked in the workforce for whatever length of time. Obviously, if the kids are older, the marriage, let's say it's a second marriage, but wife has quit her job to help raise the children from the first marriage. They don't have any more children. They're getting divorced only 2 years, 3 years later. And obviously it's probably not a maintenance case. So length of the marriage is also a factor in the whole process. When I started doing this gig in private practice, the theory always was, if you represent a client, stay-at-home parent, tell them don't get a job because that's going to hurt their maintenance chances. Well, yeah, it hurts their maintenance chances, but in today's world, and even then, but it probably wasn't recognized as much, is if you're the stay-at-home parent, your medical insurance is as part of the family plan of the working spouse. And if you get divorced, you are no longer part of the family, and therefore you have to maintain your own medical insurance. Today, medical insurance is pretty expensive. And so if you become divorced and you are not working, you have no medical insurance. You have to go through Obamacare or find some other vehicle, or you can get it through it's available to you under federal legislation as a non-employee spouse in divorce. but you're paying it at 103% of what it was costing to cover you while you were married. So it's going to cost you a bunch of dough if you get it, if you take it as a divorced spouse of your the employee spouse. So you really got to have medical insurance, particularly if you're 45, 50 years old and you're getting divorced and you have medical insurance and you've got a pre-existing condition. There's a lot of factors that if you're not working and you're taking medication, there's a lot of expense that goes with it. And so I seldom, and later in my private practice, encourage the stay-at-home parent to stay at home. And on the bench, the first thing I always looked at when I had a stay-at-home parent and I was dealing with maintenance, I want to know what the medical insurance was going to cost. And I always make sure the maintenance portion of that portion of the maintenance was paid directly by husband, if he was the working spouse, to the insurance carrier, so that wife couldn't take money from, pay Peter to, instead of Paul, so to speak. So that
Rob Peter to pay Paul.
Rob Peter, thanks, to pay Paul. And so that way I always knew the medical insurance. But yeah, medical insurance is an important deal. And it's something that I think judges can't ignore, and that divorce lawyers shouldn't ignore when they have a stay-at-home parent.
This might be not be a universal truth, but it strikes me that if that stay-at-home mom decided that he was going to go out and get a part-time job perhaps, that could be psychologically liberating in terms of worrying about whether the wife was going to pay the maintenance and those sorts of things. It gives a little more leverage. Do you see it that way? Or am I just...
I don't know that I fully understand your question. I think the benefit to working is, if nothing else, the having interaction with being in the community rather than just dealing with your children. But the other part you've got now, a lot of this pandemic, of course, with it's just cost a lot of people their jobs, and they can't get back, or now a lot of people decide they want to homeschool their kids, and so that's a job unto itself. And so I've not had it. I didn't have it when I was on the bench, and I haven't had it in what I'm doing since I retired. But I can see that being a question. Is I don't want mom is working, and mom doesn't want to homeschool. Dad has been a stay-at-home dad. He wants to homeschool because that's what he's been doing for the last 6, 8, 10, 12 months. And the judge having to decide whether that judge is going to approve of homeschooling or not. When, if there's no homeschooling, Dad's going to have to get out and get a job. And I think that's one of the issues that this pandemic may create.
I can see that. By the way, just a quick question. How is maintenance handled under the tax laws?
It used to be deductible to the payor and income to the payee. The Trump tax legislation took that away. It's now it's not taxable income. It's to the recipient. It's not deductible income to the payor. And what that has done, in my eyes, has created a big mess, because you could settle a case by getting more dollars to the stay-at-home parent by labeling it maintenance. Because if the stay-at-home parent was probably in a 15, 20% tax bracket, the payor might be in a 40% tax bracket. So therefore, if you've got $100 going from payor, 40% of that would have gone to taxes anyway. So he's saving money by paying her $100, and she's only has to pay $20. So it's sort of, quote, win-win situation, because payor gets to deduct the maintenance. But the Trump legislation changed that. I don't know why they got in the middle of that problem, but they did. And maybe because, and I can't say maybe, because if most of the people that wanted these tax changes were the higher income guys or gals, then, and they had a maintenance problem, I would think they'd want it deductible. But it's made, in my opinion, and I'm not doing a lot, I'm not I'm doing some mediation, so I'm dealing with it. It's made it much more difficult for me to try and settle cases where there's gonna be some maintenance, because I can't sell it that it's really not gonna cost you the total amount, because some of that would have gone to IRS anyway.
I could see.
So I have no idea why.
That's
that happened.
unfortunate. I agree
It
with
is,
you.
and I messed with that.
Now,
So-
you mentioned, if I may interrupt, we've got 10 more minutes to go on our first session here. You said something about mediation. Tell us what that is and what you are doing in that.
Mediation
Context.
means it's usually one person, meaning like myself, could be a lawyer, could be a retired judge, who's asked to sit down with the two people and make the effort to have them come to grips with their issues and settle the case out of court, so the judge doesn't have to make the decision. And so what you try and do as a mediator is understand the issues and try and help each of the litigants, each of the people, understand the failings in their arguments or the benefits in their arguments. The real sale for me, the sale piece of mediation is the following. Number one, you get some input into the resolution. Number two, you get divorced pretty quickly. Because if you walk out of a mediation session and you resolved everything, it just takes the lawyers to write it up, and off you go and you're divorced, rather than waiting to get a court date and having a judge hear your case and having it take God knows how long to get your first court date and how long to get your last court date,
Especially with the pandemic.
especially with the pandemic.
What do you tell people about, in say, St. Louis County? When can they expect a contested divorce to be heard?
Tough to know. I mean, the judges are doing the best they can. A lot of them are doing Zoom hearings. Whether you want to try your divorce case on via Zoom, if I was a lawyer, I wouldn't want to do it. Let me go back. Let me save that, because let me come back to the third piece, importance of mediation, is money. How much money do you want to pay your lawyers to find out that you're right, or the other side is wrong? And so you can pay me an hourly rate, or you can pay your lawyer per lawyer, and maybe a guardian ad litem, my rate times 3. And if you're arguing over dollars, it's really easy to figure out what the cost-benefit relationship is. You're going to spend X dollars to find out that you're right. She wants X, you want to pay X minus. How much money do you want to spend when the difference is $1,000 a month over 3 years? That's $36,000. Maybe you pay it now instead of paying the lawyers $50,000 combined. So maybe you come come halfway between. What I also tell them is we as judges we're very good at one thing. We really are. Some of us are good at a lot of things, but we're all good at one thing, and that's cutting babies in half. You want $5,000 a month, she wants $6,000 a month. Sounds like a $5,500 case to me. You want to pay $1,000, she wants $1,500. Sounds like a $1,250 a month case to me. So I try and convince people that what's going to happen when you get in court is, if that's your difference, the lawyer's going to have a conference with the judge, and the judge is going to say, why can't you settle it for halfway between? And the lawyers come out and they talk to you, and by that time you spend a lot of money, and you don't want to spend any more money, and that you can get the case over today because you're in court, and so all that. So that's what mediation does, okay? And that's the benefit to it. And since I'm 74, I forgot the other part of your question.
Well, I have too, by the way, since I'm 74. But let's talk and end this session, if we may, by talking about attorney's fees. And let me tell you what my experience oftentimes was in the few cases. And that is, especially the husband would say, we can settle this case, I'll give her everything she wants, but I'll be darned if I'm going to ever pay her lawyer. And that, I tell them, is a foolish issue in most instances to be hung up on. Tell us about your experience with respect to attorney's fees and how they get paid.
Your assessment is 100% correct. But he also doesn't want to pay her maintenance. He also doesn't see why she should get 50% of the property. So it's just one in a long list of complaints by whichever side has the perception that the other one's the reason why the marriage is broken up. The other one is the other parent's being greedy, etc. So it's from my perspective, it's just one more dollar that you've got to figure out whether dollars get transferred or not. But attorney's fees are a major stumbling block. So when I was in private practice, and there's a lot of older lawyers, many of whom, God rest their soul, are gone, whom I learned from, as I'm sure you did too. And one of the ones I learned from was Alan Zerman, who is sadly going to meet his maker, one of the all-time great guys in America. So I'm in private practice, and we're arguing. He says, I want $5,000 in attorney's fees. And my guy says, I don't pay $5,000. Alan says to me, Frawley, what you need to do is have him pay me $5,000 out of their bank account, and you need to take $5,000. It's marital money. And so basically, she's paying me, and he's paying you. And the more I thought about it, yeah, that's right. If the case is ultimately 50-50, and there's 20 grand in the account, and 5 grand goes to him, and 5 grand comes to me, we've really taken the 10 grand that would have been divided anyway. So what the piece is where it becomes problematic is at the back end when somebody's got an exorbitant fee and the other one doesn't have, where there's a wide disparity in fees, or where one spouse has been paid all the way during the marriage and the other one hasn't. And so now it becomes part of the property division, if you will. If wife's fees have not been paid during the marriage, she's going to want, quote, more of the assets because she's got to pay her lawyer. Or if she's not going to get more of the assets, husband is going to be asked to pay some of her lawyer's fees. So I always tried to figure out when I was in private practice, I tried to follow Alan's advice. And when I went on the bench, it was a little harder because I didn't have control over that piece. But attorney's fees are a problem because each spouse views the other lawyer as having run up the cost.
And you do see that from the bench.
But usually it's the client. Some clients are very needy. And they are they need more, they're not as confident in their decision making, and therefore they need more reassurance from their lawyer. Some lawyers will terminate phone calls more quickly than others. Some clients never call, except when there's a problem. I had a client. He was a good guy in many ways. He called seldom. I never heard from him, except when there was a problem. It might be months. I'd send him a bill, paid it by return mail. It was like a lawyer's dream. Calls you when he needs you, doesn't bother you with what he doesn't need, and also keeps the fees under control because he's only calling when there's a problem. And so part of the fees are the product of how much time the lawyer needs, how much time the litigant needs with the lawyer. But the rates are extremely high now. I mean, so you need to be careful with your lawyer when you call them because their overhead's high. So the rates are high. When I was in private practice, if we could keep our overhead under 40%, that was incredible. And now I don't know what the percentage is, but I suspect if it's not even close to 40, it's probably 45 to 50%. Well, that means for every dollar you charge, 50% of it's going to rent, staff, whatever else you've got. So if your rate's $400 an hour, you're only putting $200 in your pocket, which is not disparaging that, but it's not like the 400's all going into your pocket.
I hear you.
It's tough.
I see we're out of time for Act 1, although I will ask Kevin, if he has any questions that come to mind for Judge Frawley.
My famous question is always about church and clergy and how, are they ever involved? Is that ever part of the equation?
Can be in a custody part of it, Kevin, in that faith can become an issue or absence thereof, particularly in my work, mixed marriages. Catholic marries a non-Catholic. They promise to raise the children Catholic as part of, if they're married in the church. A second marriage of a Catholic, they can't get married in the church without a church annulment. Obviously, a Christian and a Jew may have made a decision when they got married how they would raise the children, and now they're getting divorced. That becomes maybe an issue to argue about.
How about pastoral counseling?
I have my own views on that, so I'm saying it to that. I have some reservations with priests doing the counseling in that they've never lived it. And on the other hand, I think the world of my pastor, and I wouldn't have a problem with them doing it because he's just real. So my generic as to Catholic priests is kind of, I'm not sure they totally get it. But the pastors that are in Christian faith that are married and understand the dynamics in a marriage, I think is fine. And because they understand there's a dynamic that you have to be able to appreciate in that, although you may think you're always right, that doesn't mean you're always going to win. And there's times when you have to give in. There's times where you have to recognize this is not a hill to die for. This is a time to walk away. And so I think pastoral counseling can be very beneficial. I'm not sure group pastoral counseling can have as much impact. But on the other hand, if the pastor knows the people, not just the couple, but if it's multiple couples, I think that's the benefit. I mean, it's more for pastoral counseling, it's more, do you have a relationship with the people? So you know who they are in the context of what maybe the dynamics of the family are.
On that sage and wise advice, including don't die on the hill, back off. We'll close out Act 1 and look forward to hearing from Tom on Act 2, which will principally focus on child custody issues. Thank you, everyone, for being with us. Thank you, Tom.
My pleasure.